just when we thought we had it all settled. The bars across the country, and now particularly the American Bar Association, are suggesting that lawyers be restricted in what and how they advertise. In earlier decades, it was, we thought, crystal clear that the only regulation on advertising was truth. So lawyers prepared television ads, they prepared classified ads and what have you. They conducted themselves in personal interaction, in networking and the like, along these lines that it all had to be truthful. Now technology has taken us to a new level. The new level is social media. Now all of a sudden, the state bars think that they're going to have the right to regulate how lawyers present themselves in this new social media, Facebook, LinkedIn, and so forth. The American Bar Association has put forth a request for comment, and in the blogosphere there is a tremendous amount of back and forth about how lawyers, particularly sole and small firm practitioners, should be allowed to say anything they want on the blogosphere, because that levels the playing field with the big law firms, so long as it's truthful. The bars are not quite willing to go along with this. Particularly Texas and Florida, they have some very restrictive provisions. And Kentucky now says, well, you can do it provided you get pre-approval, and oh, by the way, for every time you want to move forward, you're going to have to pay us a fee of $75. Another very clever way of raising non-dues revenue for financially strapped bar associations. It seems to me that the logic of regulation just doesn't hold water. If you can advertise on television, you ought to be able to talk about cases, you ought to be able to talk about new trends in the law, you ought to be able to talk about that which is your expertise, whether it be family law, driving under the influence, corporate security work, whatever it might be. You are enabling the public to become educated about the area in which you practice. And oh, by the way, yeah, I know, it does get you perceived to be the expert in the field. But you're also educating the public. What is wrong with this? As long as you are truthful in what you say. I think the bars will be forced to recant. I think they're going to be forced to back off. The law consulting, the law marketing consulting world and lawyers themselves are beginning to raise up their hackles and say, wait a minute, you can't do this. And if enough lawyers respond to the request for commentary, I think the bar will listen. Does this benefit sole and small firm practitioners more than the large firm lawyers? I'm not sure it does. You have to give cognizance to the fact that more than 70% of the legal population in private practice is in fact sole and small firm lawyers. So just by sheer numbers, yes, it does impact smaller firm lawyers more than it does larger firm lawyers. But it impacts all lawyers. So take a look at what you're doing in your blogging, in your social media approaches, how you create the profile that you use on Facebook and on LinkedIn, and make sure that what you're saying is truthful. Once you do that, I think you're going to be okay. If you've got any comments or further thoughts about this, please respond. Please send a note to me at edpohl@lawbiz.com. I'd like to enter into a dialogue with you about this, or better yet, join us at lawbizforum.com and post your thoughts there for everybody to interact in the dialogue. Thanks for joining us.